Breaking news: Supreme Court has just shocked the nation with an 8-1 emergency order that could permanently alter the future of the Second Amendment. This isn't a normal ruling, not a slow-moving case working its way through the system. This was fast, unexpected, and decisive. In just a matter of hours, the court's decision has sent waves through Washington and ignited fierce debate across the country. Gun rights advocates are calling it a monumental defense of constitutional liberty, while opponents warn it could unravel years of firearm regulation. One justice stood alone in dissent, and that lone voice is raising serious questions tonight. What triggered this emergency order? Why did the court act so swiftly? And how could this decision reshape every future battle over the right to bear arms? Let's get into it. After months of chaos have been unfolding in lower federal courts, where judges are issuing conflicting rulings about gun possession rights with absolutely no consistency. One circuit court interprets recent Supreme Court precedent one way, while another circuit reads the exact same precedent completely differently. The result is a constitutional nightmare where your Second Amendment rights depend entirely on which state you happen to live in or which federal courthouse hears your case. Gun owners in some jurisdictions face prosecution under regulations that courts in other areas have declared unconstitutional. Law enforcement agencies don't know which rules they're supposed to enforce, and attorneys can't give their clients clear guidance because the legal landscape changes depending on geography. Meanwhile, several states have openly pushed back against federal guidelines, claiming those policies violate constitutional standards established in previous Supreme Court decisions. State attorneys general file briefs arguing that federal regulators are essentially ignoring judicial precedent and implementing restrictions that the courts have already said go too far. The situation reaches a boiling point when multiple parties file emergency petitions asking the Supreme Court to intervene immediately, arguing that irreparable constitutional harm is occurring every single day this confusion continues. That's the powder keg that leads to this hypothetical emergency order. Now picture the Supreme Court stepping in with swift, decisive action that stuns the legal world. 8 justices agree that an emergency order is necessary to stop what they characterize as ongoing constitutional violations that can't wait for the standard appellate timeline. The emergency order temporarily halts enforcement of a major federal gun possession restriction while the underlying legal challenges proceed through the court. But here's what makes this so significant. Emergency relief from the Supreme Court is extraordinarily rare and usually signals that the justices have very serious concerns about what's happening. By granting this stay in an 8-1 vote, the court is essentially telegraphing where it's likely to come out when it eventually hears the full case. The order emphasizes a principle that would be absolutely crucial. Constitutional protections don't get suspended or diminished just because litigation is ongoing. The Second Amendment doesn't go on pause while courts slowly work through appeals. If there's a substantial likelihood that a restriction is unconstitutional, and if enforcing that restriction causes irreparable harm to constitutional rights, then the court must act to preserve the status quo until the legal process reaches its conclusion. This emergency order would send a powerful message that the justices take Second Amendment rights seriously and won't tolerate lengthy periods where citizens are potentially being deprived of constitutional protections while waiting for the judicial system to catch up. The 8-1 breakdown would be absolutely fascinating and would tell us something important about how clear the constitutional issue appeared to the justices. 8 members of the court spanning the ideological spectrum, from the most conservative to some of the more moderate justices, all agreeing that emergency action was warranted. This wouldn't be the usual 5-4 or 6-3 split along predictable ideological lines. Instead, it would represent an unusually broad consensus that something had gone seriously wrong and needed immediate correction. The majority opinion would likely emphasize that this isn't about policy preferences or partisan politics, it's about fundamental constitutional principles that transcend those divisions. When justices who often disagree about other issues come together this decisively, it suggests that the constitutional violation was particularly clear or particularly serious. Now the Department of Justice would react to this emergency order, and this is where things get really tense. Picture the Attorney General's office immediately releasing a statement that carefully walks a line between respecting the court's authority and making clear that the DOJ fundamentally disagrees with this decision. The statement expresses concern that the emergency order disrupts ongoing enforcement efforts designed to protect public safety, and suggests that it creates uncertainty for law enforcement personnel who are simply trying to do their jobs. Behind that diplomatic language, though, Justice Department lawyers and policy experts who are absolutely frustrated. In their view, the regulations at issue were carefully crafted to address genuine public safety concerns while respecting constitutional limits. They would argue that the court is second-guessing expert judgment about what restrictions are necessary to keep communities safe. Internal DOJ meetings would focus on damage control, how to limit the scope of the emergency order, whether aspects of enforcement can continue under different legal theories, and what strategies might preserve at least some regulatory framework while complying with the court's directive. Some officials might even quietly question whether the court has the technical expertise to make these kinds of judgments about complex public safety regulation. The department wouldn't be openly defying the order that would be a constitutional crisis, but they'd be looking for every possible way to work around it, and that resistance would set up ongoing tension between the judicial and executive branches. The political firestorm that would erupt in this would be absolutely intense, lighting up Washington and state capitals across the nation almost instantly. Lawmakers who support Second Amendment rights calling press conferences to celebrate what they'd characterize as the court finally taking a stand against federal overreach and bureaucratic abuse. These politicians would argue that the 8-1 vote proves how obviously unconstitutional the government's actions had been when even justices from different philosophical traditions agree. It's a sign that officials had crossed a clear line. Pro-Second Amendment legislators would probably introduce bills to codify the principles underlying the court's emergency order, trying to turn this judicial victory into statutory protections that would be harder for future administrations to undo. But the equally passionate response from gun control advocates who would see this emergency order as reckless and dangerous. State officials in jurisdictions with strict firearms laws would hold their own press conferences warning that the court is prioritizing abstract legal theories over people's lives. Picture how major Second Amendment advocacy organizations would respond to this emergency order, and you can the energy and determination it would unleash. Organizations like Gun Owners of America and the Firearms Policy Coalition would view this as an absolutely monumental moment, the kind of breakthrough they've been working toward for decades. Their press releases would emphasize that this 8-1 emergency order represents a fundamental shift in how courts approach Second Amendment cases, moving from grudging recognition of gun rights toward robust protection of constitutional principles. These organizations would tell their members that momentum is building, that the Supreme Court is listening, and that now is the time to press forward with additional challenges to regulations that might not survive this new constitutional scrutiny. Legal experts analyzing this hypothetical 8-1 emergency order would have a field day, publishing articles and giving interviews trying to explain what it means and what comes next. Constitutional scholars would emphasize how unusual it is for the Supreme Court to issue emergency relief in such a lopsided vote, suggesting that the legal issues must have been exceptionally clear. Some analysts would focus on the procedural significance, explaining that emergency orders typically require showing four things: likelihood of success on the merits, irreparable harm without relief, balance of equities favoring the applicant, and consistency with the public interest. For 8 justices to agree that all those factors were met suggests they believed the constitutional case was quite strong. Other experts would focus on substantive implications, arguing that this emergency order will influence how lower courts handle dozens of similar cases that are currently pending. Judges who might have been inclined to uphold restrictions would now have to reckon with a clear signal from the Supreme Court that such regulations face serious constitutional problems. Legal scholars would debate whether this represents the court embracing a more aggressive role in protecting Second Amendment rights or whether it's simply a necessary correction to lower court confusion. So what happens next in this is where things get really interesting for the future of constitutional law. Picture courts across America now having to grapple with the implications of this emergency order. Federal district judges with pending firearms cases on their dockets would need to reconsider their analyses in light of what 8 Supreme Court justices just signaled. Some judges would issue new rulings striking down regulations that they previously might have upheld, reasoning that the emergency order makes clear where the court is heading on these issues. Others would try to distinguish their cases from the specific circumstances that triggered the emergency order, attempting to preserve some regulatory authority while acknowledging the new constitutional landscape. States with strict gun control laws would face difficult choices. Do they defend their regulations knowing that the Supreme Court appears skeptical, or do they modify their approaches to try to satisfy what they anticipate the court's eventual standard will be? Meanwhile, the underlying litigation that triggered the emergency order would continue working through the system, eventually reaching the Supreme Court for a full hearing and final decision. Tonight, in this we've explored something truly extraordinary, an 8-1 emergency order from the Supreme Court that would fundamentally reshape how America thinks about Second Amendment preservation. This hypothetical ruling would represent the court acting with unusual decisiveness and an unusually broad consensus, signaling that constitutional concerns were too serious to wait for the slow grinding of normal appellate procedures. The emergency order would send shockwaves through the legal system, embolden Second Amendment advocates who would see it as vindication, alarm gun control supporters who would view it as dangerous judicial activism, and create enormous uncertainty about what rules actually govern firearms possession in America. The DOJ's resistance would demonstrate that judicial decisions don't automatically translate into enthusiastic executive branch compliance, especially when officials believe their core public safety missions are being undermined. The political ramifications would be enormous, affecting everything from state legislation to national campaigns to the broader cultural debate about rights and responsibilities in a free society. And the legal community would spend months or even years working through the implications, applying this hypothetical emergency order to hundreds of specific situations and regulations. If this were real, it would represent a pivotal moment where the Supreme Court decisively intervened to defend constitutional rights that it believed were under threat, regardless of the political controversy such action would generate. The story would be far from over. This would just be the beginning of a new chapter in America's ongoing conversation about the Second Amendment, constitutional interpretation, and the proper balance between individual liberty and collective security. This has been a speculative deep dive into how such a might unfold, raising important questions about judicial authority, governmental power, and the fundamental rights that define American citizenship. The actual fight over these principles continues in real courts and real legislatures every day, and understanding these dynamics helps us engage more thoughtfully with the constitutional questions that shape our society.